Welcome to Work Comp Talk, a podcast dedicated to all the injured workers here in California. I want to thank our lovely sponsors, Pacific Workers, the lawyers for injured workers. If you have not yet been able to connect with an attorney who can feel like they're listening to you, who is going to be there every step of the way, I highly encourage you to check them out at pacificworkers.com, especially if you're starting to get into some issues within your workers' compensation claim. My name is Carmen, your host, and this is the Best of Work Comp Talk series where we highlight the best episodes from the podcast into one. It's very important for you to hit the description. That way you get actual links to the full episodes of those topics we will be highlighting in this episode. And I also wanted to give you a heads up. Season 5 is coming up. It's coming up pretty soon, and I'm excited because I'm going to be able to share so much more knowledge with you as I embark this new season, along with many other co-hosts that are also attorneys for workers' compensation. So we're going to get different views and different concepts, different ideas that are going to come from these other attorneys. And you'll also get to meet other great people that belong to Pacific Workers. So I hope you join us for this. And I also hope you like this best of Work Comp Talk. I'll catch you guys next time. Today's episode is one of the hottest trending topics ever in the history of workers' comp. And it's not necessarily settlements, surprisingly. Yeah, you would think settlements is what everybody wants to know about. It's more so with something that's hitting us up around the corner, the summertime, which with summer, we all know vacation time comes around. So it's in regards to that. Taking vacation time while on workers' comp. Should I take my vacation time? Like, how does that work? Personal time off. Say, for example, that I had a planned vacation for July and we're in April and I'm injured and I really want to utilize that time during my vacation time. Am I obligated to use it because I got injured?
California is an at-will employment state, which means that unless you have a contract stating otherwise, your employment is at will, meaning that you can be terminated at any time for any reason. And so long as the employer is providing you the bare minimum state and federally mandated benefits and rights, they're okay to do that. And so what comes up a lot in workers' comp is where someone maybe isn't receiving benefits, but they can't work. And their employer says, well, if you're not going to work, you need to be on paid vacation or PTO, if that's sick time or otherwise. Technically, employers are legally allowed to terminate you while you're off of work, even if you are collecting workers' compensation benefits, provided, again, that there's a lawful reason for it in the first place. They can't just arbitrarily terminate you and then not terminate someone else in the same position, because that may be a form of discrimination.
It's like the only way they can make ends meet is by taking my vacation time, all my PTO, all my sick days, like trying to get a payment while I'm trying to recover, which kind of sucks for the injured worker. It's like, you didn't tell yourself, let me get injured today. Like, that sucks, because say you do use up all your time and you don't get fired, you're not going anywhere for the rest of the year.
The vacation time that you have is considered an accrued benefit, meaning it's yours.
Right.
And so it's not considered a benefit, meaning that if you are in a workers' compensation case and for whatever reason your case is denied and it's taking a while to fight and you have to burn through some PTO time to cover yourself, the insurance carrier, or if it's a self-insured employer, does not get credit for the vacation time. Well, if it turns out, for example, that your case was denied and you should have been on temporary disability that whole time, to the extent you should have been paid temporary disability, that would be something the lawyer would get back for you. So even if the period of time that you drew vacation time should have been temporary disability, you still get the temporary disability, even though, you were still kind of paid for that time, but it's because it was your money.
Yeah.
That was paid in the first place.
Man, that's like a really scary situation.
A judge doesn't have the authority in workers' comp cases to order that vacation time spent while you're recovering from injury is reinstated. If there's a discrimination case, yes, but just in the course of a normal case where there's temporary disability it's owed and they burn through vacation time, no matter what we do, a judge has zero power to reinstate that.
Yeah.
And so even though the judge may be able to award temporary disability during that time, you're right, you're not going to get that vacation time back,
Yeah.
like per se. So you're not going to get the time off of work to go use to spend with your family or elsewhere. It's just you use that to recover, which was not an anticipated use, unfortunately.
Today we're going to be discovering a topic that is very trendy, and that is discrimination while you're on workers' comp or in general, also known as the 132A. Let's talk about the 132A, discrimination laws. It's a lot of things that people don't even know exist, but they do.
132A refers to a code section of the labor code in California, and that code section in particular addresses discrimination in the form of retaliation for someone either pursuing or making known their intention to pursue a workers' comp case. In 132A cases, there's generally there's a time continuum where it matches up, right? Someone was a great performer at work, all of a sudden they get hurt, they say they want to report a work comp case, and then all of a sudden you notice things start to change. You could be passed over for a promotion, you could have your pay docked, or you could have your pay significantly altered. Maybe you're making $25 an hour before and your boss says, hey, you know what, I think we're going to be reducing your pay due to quote unquote budget cuts or whatever the hell it is. It's a fine line, right? Because there's become a popular term, I think, in the last few years for, I don't want to say little, but what people perceive to be, I don't know how to say it, either unconscious or sly ways of picking at people, called microaggressions.
So now when you say you need to have meat behind, this also embodies having that sufficient evidence that's going to support and back up your theory of being discriminated against.
I had a gal, she was a residential property manager at a big apartment complex in the East Bay. So this gal's working on the property, she gets hurt, she files a workers' comp case. Apparently the property manager was livid about the fact that she filed a work comp case, thought it was all bullshit, literally sends her a text message that says, we've won all these evictions, and unless you want to be evicted, you should come talk to me, and you need to drop your case, and we won't evict you. Literally threatening to kick this woman out of her home. In that particular case, I basically sent that text message to the defense attorney, and they just paid. They absolutely just paid. In workers' comp, you generally have two different attorneys for the 132A and the claim, because workers' comp claims themselves, they're considered no fault, right? And so they are covered by insurance. 132A cases are against the employer directly, and there's no insurance that covers that. And so you'll see in workers' comp case where there's a 132A component, there's an attorney usually for the insurance company, and then there's an attorney who represents the employer in that capacity. We see sometimes where people get hurt, they report the claim, and all of a sudden they get reassigned a different shift. So it's, oh, you were a day shift person, now we need you for night shift or you're fired. Sometimes it's that, or sometimes it's really, like I said earlier, these microaggressions, these little ticks and picking at people. And it's every case is different, but unfortunately we see it a lot. And it's not just this one residential property manager, it's giant companies that do it too. Keep notes. I always tell people, keep notes. If you're communicating about the way you've been treated or your injury or whatever it is, put it in writing. Instead of having a conversation with HR, send them an email, send them a confirming letter, whatever the case is, just document and document. Because that's really the key in bolstering your own credibility as a witness. Or they make up new policies, or they change policies, or administer it differently because that particular person is injured. And so that happens a lot. That in and of itself could be considered work comp retaliation under a 132A claim. I think you really have to understand the nuances. There's a couple of specific ones. For example, workers' comp for 132A claims, the damages are pretty well defined, right? It's max $10,000 penalty, which is what I asked for on that case that I just described and we got. Not many people ask for that because who wants to go back to a shitty employer? There are parallel civil cases that oftentimes run hand in hand with 132A claims. So we have the California Fair Employment Housing Act, and we also have Americans with Disability Act. And those are both different avenues to pursue cases for things like protected class-based discrimination. And so disability discrimination under Fair Employment Housing Act or Americans with Disability Act is different than a retaliation claim. There's no protections under FEHA or the ADA for workers' comp retaliation. There's no cause of action. It's the exclusive jurisdiction of the Work Comp Appeals Board. And understanding the nuance between those and understanding, hey, do I have a 132A claim here? Or do I have a Fair Employment Housing Act claim? Or do I have both?
Yeah.
And we do have cases where there's both. We have cases where there's just a FEHA case. And so I think you really have to understand the nuance there and understand what's the better avenue for me to recover, if at all. The damages in Fair Employment Housing Act cases are far more substantial than in a 132A claim, for example. But they cover different things. You have to understand the nuances. One's a federal case, one's a work comp case. And unless you understand how to navigate that, as well as what's required to actually proceed in those cases, the paperwork, the complaints, you have to get a right to sue letter from the DFEH. It's not something that's just, oh yeah, I can read online how to do this and do it. It's complicated. Sometimes it's right there in your face, sometimes it's not.
We're excited to take down another FAQ video. If you have questions, please drop comments into our YouTube videos and we do answer them as best as we can. This does not create a relationship between your attorney. This is not any type of legal advice. It's just answering some questions. If you want to get a one-on-one with an attorney, we'd highly suggest for you to schedule a case evaluation with any workers' comp law firm. First question, Bilal, I hope you're ready for this one. It has to do with QMEs. What's the purpose of the QME if the defense team still doesn't agree with the report?
So you go to a QME when there's a disagreement about the case in general, right? Once you're there, either party has the ability to disagree with the QME and ask for another report or take the QME's deposition. You may get a QME that's favorable, but the defense may not like that. It doesn't mean automatically if the QME goes in your favor that benefits start going in. If the defense doesn't start benefits or they disagree, sometimes you have to force them to do that. You have to take them to court. You have to try the issue if there's an issue that needs trying. Sometimes the QME will give their opinion and the defense will say, okay, it is what it is. We'll accept the case, but it depends on everything that's going on in the case.
Knowing what QME you're going to go to, there's QMEs that are insurance friendly, meaning they side more with the insurance company, though there are QMEs also that side more with the injured worker. And then there's the neutral ones, the ones that don't play sides and they do what they have to do. So it's really important to know your QMEs. Yep. What happens if 3 months after your surgery, your doctor quits the network and then you're assigned to a new doctor? What are your options then?
So if there's a doctor that's no longer in the network, they can request to continue treating you, even outside of the network, provided that you have a medical condition that requires ongoing care that's something serious like post-surgical conditions. People are not in a great spot. Passing them off to someone else, probably not the best idea. Assuming that's not the case, if you've done your post-surgical PT and recovery and there's nothing there that really requires your ongoing specialized care with this one particular doctor, then you probably have to find a new doctor within the network. There will be cases where the doctor, maybe it's not them being out of network, but they've retired.
Should I settle or should I take the medical as long as I can? If they opt to close out future medical with a workers' comp, does that settlement count towards, I guess they have an injury lawsuit on top of it. So it says, does this settlement count towards subrogation against my third-party personal injury suit?
Sometimes when you're hurt at work, due to the negligence of a third party, you can file a work comp case and sue the negligent party in civil court. But that means you ultimately can't double dip. In workers' comp, to the extent you receive a settlement from a personal injury case, the workers' comp can assert a credit against whatever benefits and treatment you're entitled to in the workers' comp case. The same principle applies from workers' comp to the personal injury case, where if you settle your workers' comp case first, the personal injury case is going to say, hey, you already got X number of dollars. But your work comp carrier, in that case, would file a lien on your personal injury case. You can't double dip. You're 50% at fault or whatever it is, so that's what your percentage should be reduced by.
Does your attorney collect fees on future medical care after your case has been settled?
So if you settle your case with an open medical award, the insurance carrier is still on the hook for providing care. Or maybe the client comes to us and says, I'm not using the medical care anymore, or I want to do this on my own. We can sometimes go back to the carrier and try and settle out the value of their future medical care, in which case we take a percentage of whatever that number is. So yes, if you decided you wanted to settle out your medical later and we helped you do that, we would ask for a fee.
Can I ask, once the doc tells you that you are MMI, does the info get transferred over to the insurance company? And does the insurance company automatically contact you to discuss settlement or anything at all? I've been MMI'd by my doctor and I haven't gotten contacted.
Your doctor should write an MMI report The permanent work restrictions should go to your employer so that they can engage in the good faith reasonable accommodation process to determine if they can offer you permanent modified work within your restrictions. The report should be sent to the insurance adjuster. The insurance adjuster has an obligation to review the report. If you are permanent stationary or MMI and you have permanent disability and you aren't working, then they should start advancing you permanent disability benefits.
Okay. There is a timeline from the moment that you get MMI to the moment they offer you a settlement? You don't have to wait months?
Depends on what's going on internally for them. They may get it and be like, oh man, this report sucks for us. How do we fight this thing? What do we do to challenge this? Or they may say, hey, this report's great, we're fine with it, whatever, we'll settle on this. If they want to settle on it, usually they'll reach out to you pretty quick. I've seen that happen for sure. They don't send out notices, they just hope you disappear. But as long as you have a need for future medical care, and as long as that care is associated with your date of injury, you have an ongoing lifetime right to medical care. That's why, at least for my cases, I always encourage my clients to aggressively pursue treatment provided that the doctor's confident it'll fix them or make them better, because there's always risk. And if your condition does deteriorate and it's past 5 years, you can't reopen it.
Yeah.
We can file a new case against that current employer. But there are cases where people just naturally get worse. There's no new injury. They haven't been back to work. And that's just the way the law is, unfortunately.
So it's really important to pay attention to what the doctor tells you right before you, or at least when you're getting dismissed, in the sense of, okay, I'm going to, settle with the STIPs. If the doctor's giving me an option to say there might be a surgery down the line that's going to be successful, then you're good. That's a great tip. It's a timeline that people can say, hey, I have up to 5 years. I really need to reevaluate, maybe right before that mark, to figure out my next move. Otherwise, your options are very limited after that.
Maybe you start developing a situation where you need treatment on a body part that wasn't initially part of your settlement. And that's subject to 5 years of reopening.
Can I get fired while I'm on workers' comp?
Yeah, you can, unfortunately. So California is an at-will state, which means employment's at will, and you can be terminated at any time for any lawful reason, provided you don't have a contract. If you go out on workers' comp and then 3 weeks later they say, oh, you're fired, and they can't articulate a reason for it, they're maybe in some trouble for disability discrimination or retaliation. And another example of lawful termination would be if the company has a policy. So if the company says, doesn't matter who you are, our policy is that we will keep you on for 24 months following a work injury, and at that 24-month mark, if you cannot come back to work, we let you go.
Great. I think we have everything we can squeeze in with the time that we have allocated for our podcast. We have some great news. We have a live webinar where we are going to be sharing a lot of information regarding the California workers' comp system. That's going to be virtual. We're going to be pushing it out on our social media accounts, so keep an eye out for that. Maybe you can join us, and there is going to be a live Q&A session at the end of the seminar, so it gives you this connection to make those questions in person as well. Thank you for answering those questions. Thank you for asking the questions.
Keep
we'll catch
them coming.
You guys.